Members of the LGBTQ community face unique issues and challenges when planning their estate. So it's really important to consider the following. One, if you have no will, assets are distributed to their heirs in Maryland, and that's set by statute. So heirs can include your parents, children, siblings, and even aunts and uncles. Domestic partners are not included as legal heirs in Maryland unless you're legally married and will more than likely be disinherited regardless of your intentions. So, therefore, if you want to determine what happens to your property and your assets, having a will or a trust is a must. Second of all, people will question, well, can't my family just contest my will anyway? Yes, they can, but they have to have basis and authority grounds to contest your will, such as disability, incompetence, or incapacity. If you believe that this is a situation that could happen, then you may want to save your partner the pain and anguish of going through that process by creating a trust. Establishing a trust can also offer superior asset protection compared to a will. The third consideration when planning is inheritance tax. So in Maryland, again, if you're not legally married, the decedent's partner will be subject to an inheritance tax. So this is why careful planning is so important. Next would be children. So if you have children together, many times you'll have one partner as the biological parent. It's imperative that you designate a guardian for minor children in your will or have a separate nomination of guardian. Without the will or a nomination of guardian, the courts must choose who is going to be the guardian by basically guessing who the biological parent would have preferred and what would be in the best interest of that child. The court may or may not pick the partner. Next would be real estate ownership. This is also important. There's several different ways to own and hold title to real estate that can avoid property from going through the probate process um, and to um, and to ensure that the property passes to that person's partner. Last but not least is end of life care. While you're still alive, if a person is incapacitated or incompetent, you want to make sure that good, solid powers of attorney are in place. One is a financial power of attorney to name your partner as the person to make financial and day to day decisions on your behalf. Second would be a healthcare power of attorney to name your partner as the person to make medical decisions in the event that you are not able to make your own medical decisions. And then your advance directive, or also called a living will, to direct the medical community, your family, and your partner as to what you would want happen when end of life is near, and how you want your medical treatment to go pursuant to that advance directive. You want them to follow your instructions regarding end of life care. So these are very important considerations that need to be dealt with when planning the estate. So to learn more, visit our website and download our free guide to estate planning for LGBTQ families.